Supreme Court drama. In September 2025, the High Court lifted limits on immigration raids in Los Angeles, allowing ICE agents to use race, language, occupation, and location as a part of determining suspicion. Many are calling it a major erosion of 14th Amendment equal protection rights. Today, we're breaking down what changed, what it means, and why everyone, not just immigrants, should pay attention.
The Supreme Court, in a 6-3 emergency shadow docket ruling, reversed a lower court injunction. That injunction had blocked federal agents from making stops based on race, language, employment type, or geographic location in Los Angeles. The Washington Post, plus 2reason.com plus 2. The decision doesn't fully resolve the case. It allows these enforcement tactics while the courts continue to litigate. The Washington Post Justice Kavanaugh's concurrence suggests that while race alone is not enough, it can be one factor among many. Justice Sotomayor, in dissent, argues this essentially legalizes racial profiling and violates core principles of the Equal Protection Clause and Fourth Amendment protections. The Washington Post plus 2reason.com plus 2.
To understand why this is so controversial, we need to recall the Equal Protection Clause of the 14th Amendment. It says, "No state shall deny to any person within its jurisdiction the equal protection of the laws." Historically, that has protected people from discrimination based on race, nationality, etc. The question is, can law enforcement use race or ethnicity as part of suspicion without crossing constitutional lines? This ruling pushes the boundary.
For undocumented immigrants and Latino communities in Los Angeles and similar urban centers, this could mean more frequent stops, increased fear of law enforcement, and disruption to daily life, even for those who are citizens. Because the decision was issued via the shadow docket, there's very little explanation or transparency. That means ambiguity in how policies will be applied, which increases risk of misuse. Potential for increased deportations, family disruptions, even for people who are just temporarily mistaken for non-citizens. The decision weakens judicial restraints on immigration enforcement. Lower courts can issue injunctions, but often only for specific plaintiffs, not entire states or the nation. That changes how constitutional protections are enforced in practice. Fourth Amendment concerns: stops based on race or ethnicity risk being unreasonable searches. When race is used even as one factor, it can lead to discriminatory enforcement. The dissent points this out strongly. It may set precedent. Other districts or states could see expanded roving patrols or broader immigration enforcement in public places, neighborhoods, transit hubs, workplaces, using similar multi-factor tests. Winners per this ruling: the federal government gets more leeway to enforce immigration law aggressively. Areas with high undocumented populations may see more enforcement operations. Some law enforcement agencies may view this as bolstering their tools. Losers: immigrants and their families, particularly Latinos in urban settings, people who may be profiled, communities with strong distrust of law enforcement, civil liberties organizations. Also, potential chilling effect on everyday life. People may avoid public spaces, avoid reporting crimes, or avoid interacting with institutions for fear of being stopped. Broader significance: the ruling could affect how equal protection is interpreted in other contexts, like policing, traffic stops, or employment-related checks. If race, language, or location become accepted as contributing factors, that could stretch into many areas of public life. Impact on nonprofits and local government. Community legal aid organizations will likely see a surge in demand. Local governments may face tension with state and federal agencies over enforcement policies. Trust between immigrant communities and public institutions could degrade, making public health, education, and welfare work harder. Watch for upcoming appellate rulings. The case will proceed, and more detailed opinions will clarify how far this goes. Keep an eye on decisions in the Ninth Circuit, other district courts, and possibly future SCOTUS term. Data and monitoring. Local nonprofits, civil rights groups, and journalists should monitor stops, arrests, and enforcement activity. Collect data on who is being stopped, why, and outcomes. Know your rights. For individuals, whether immigrant or citizen, understand what ICE or other federal agents are allowed to do. If you're stopped, ask if it's voluntary, ask for identification, you can refuse consent to search, etc. Policy advocacy. Support or pressure legislators and city-state governments to create policies that protect vulnerable populations. sanctuary protections, local oversight of ICE activities, transparency in enforcement. Legal challenges, expect litigation. Supporting legal aid organizations, financially or through pro bono work, could be critical.
This Supreme Court ruling is more than just a legal technicality. It touches on who is protected under the Constitution, who's free to move without fear, and how much power law enforcement has over civil liberties. For many, this could reshape everyday life. If you found this helpful, please like, comment, and subscribe. What do you think? Does this ruling go too far? Or is it necessary for enforcing immigration law? Let's talk in the comments. Thanks for watching.